Good afternoon. Today I'll be talking about copyright laws and how to stay out of litigation to be able to focus on ministry. But before I begin, I do want to state that the information that's being presented today relies on legal principles based on the federal laws in the United States. This is not legal advice. Always be sure to consult with your legal counsel to make sure that you're in compliance with the laws of your jurisdiction. So let's start by talking about what copyright is. Copyrights are a set of rights granted to creators of original works of authorship that are fixed in a tangible form of expression. Certain works can be considered copyrightable, including literary works such as books or articles or text or software, musical works, dramatic works such as plays or screenplays, performances and choreographed works, pictures, graphics, and sculptural works, motion pictures and other audiovisual works, sound recordings, and even architectural works. However, everything is not able to be copyrighted. For example, ideas and facts are not available for copyright protection. So what does a copyright give? Well, owners of a copyright are given the following 5 rights. They are given the right to copy their works. They're given the right to distribute their works. They're given the right to publicly perform those works, to display those works, and also to create derivatives of the works, including making modifications, adaptations, or translations of their copyrighted material. A derivative could also mean that the creator of the work is able to change, let's say, a book or screenplay into a film, or to take a song and put it into a book as a poem. These are rights that are given only to the owner of the copyright. So copyright ownership is obtained automatically without a need to record or register your work with the Copyright Office or any other formalities. Although registration with the Copyright Office does provide some benefits, for example, it puts others on notice that you are claiming copyright ownership, and it lets others know the year that the work was copyright protected, and this does have some implications regarding the length of copyright protection, which we'll talk about later. So who owns a copyright? Well, the author of the work or the creator of the work is the one who has the copyright. And under some circumstances, such as a work for hire agreement, the employer or the one who commissioned the work can be given the rights of the copyright holder. So a work for hire is a work that is prepared by an employee within the scope of his or her employment, or it can be work that is specifically ordered or commissioned for the following uses. Either it's a contribution to a collective work, it's part of a motion picture or other audiovisual work, it's a translation of a copyrighted work, something that's created as a supplementary work, a compilation, instructional text, a test, answer material for a test, or an atlas. These are the things that can fall under a work for hire agreement. Even if a commission work does not come within one of those categories, even if it does come within one of those categories, it does not qualify as a work for hire unless there is a written agreement that is in place that is specifically saying that the commission work is being prepared as a work for hire. And this written agreement has to be in place before the work has been prepared. So because there's so many stipulations as to what qualifies as a work for hire under a contract agreement, we often have language that says, in a contract, it will say, to the extent that the work product is not recognized as a work made for hire, as a matter of law, the contractor hereby assigns to the company any and all copyrights in and to the work product. By including this language, it ensures that even if it's not considered a work for hire under U.S. law, that there's an assignment that takes place from the contracting party from the contractor to the contracting party. Absent this, if you hire, let's say, a photographer to take pictures for you, or someone to create any other kind of creative material, they own the copyright, not you, even if you've paid for it. So now let's talk about what copyright infringement is. Copyright infringement is when an individual or an entity uses all or part of a copyrighted material without first getting permission. It can also mean if you adapt a copyrighted material, such as changing an image or changing lyrics without permission, or making translations of materials without first getting permission from the copyright holder. This constitutes copyright infringement. The third way that we encounter copyright infringement is if you even have a license to use material from the copyright holder, if you go beyond the scope of the license. So for example, if I give you a license to make 500 copies of my printed material and you make 600 copies, you've now infringed on my copyright. So now let's talk about what the penalties are for copyright infringement. Well, under US copyright law, there are certain statutory remedies that can be implemented. For example, you could have to pay up to $150,000 per infringing work if the infringement is willful. And this means that you were put on notice that you were violating someone's copyright. Also, in cases of willful infringement, you could face prison terms. Who can face these penalties? Well, the entity that directly infringed, the employee who participated in the infringement, or anyone who furthers the infringement. So if I take an infringing material and then continue to use that material or continue to share that material, I could then be held responsible for copyright infringement. And not knowing that the work is infringing is not a defense. It might save you from willful infringement penalties, but it does not save you from some of the other penalties that can also be assessed against you. So there have been court cases that deal with copyright infringement even in a church setting. There were cases of churches that have used music without permission and have had to pay huge fines, or churches that have copied music to be used for congregational singing and have also had to face fines. And sadly, we have even seen misuse within our own denomination of entities using materials without first getting permission. And while there haven't been lawsuits to date in this area, we have had to pay penalties because we have gotten letters from copyright holders stating that we have used their information without permission. And this is troubling because copyright is one form of intellectual property. It is the same as taking a book out of a store without paying for it, or taking a CD out of a store without paying for it. We're doing the same thing. And in the Bible, it clearly states, "Thou shalt not steal." So let's talk about how to avoid copyright infringement. First, we should determine whether the work that you want to use is copyright protected. If it is, then you need to get permission. You should seek written permission before using any material that appears to be copyright protected, and then obtain a license to cover the use that you're wanting to use the work for. And then you should obtain a license for all the uses that you intend to use that work for. Not all works require permission. For example, material that you create, or original material, you do not need a license to use because you are the copyright holder. Also, material in the public domain is free to use because the copyright for that material has expired. Lastly, there are some materials that copyright holders have decided to give a Creative Commons license or a public license for. And for those, you don't need to get an explicit written permission because they've already given permissions, but you do need to be careful to make sure that you're following the terms of that license, that you're not going outside the scope. But those are works that you don't need written permissions to use. So let's talk about public domain. A copyright lasts for a fixed period of time. And while the length of a copyright will depend among a number of things, depending the jurisdiction that the work was created in and the date that it was created, at some point, all copyrights eventually expire. And once a copyright lapses or expires, the work falls into the public domain, meaning that it can be used from anyone without permission of the copyright holder. In the US, there are a number of copyright laws over the years that come into play. But currently, any work that was created after 1978 has a copyright length of the life of the creator of the work, or the copyright holder, plus 70 years. Now, things that were created before 1978, they may fall under a whole host of different rules or laws regarding the copyright of the work. But what I can say is that anything that was created from 1925 and prior is probably in the public domain. Anything from after that time period, though, you really have to do some research to see if it is still copyright protected or not. And you can't rely on whether or not a material has the little C symbol next to it, or has notification on it, because that is not a requirement of copyright ownership in the United States anymore, even though at one point it was. So one area that many people like to use to justify using copyrighted material is this concept of fair use. And under the fair use doctrine of the United States copyright statute, it is permissible to use limited portions of a work, including quotes, for purposes such as commentary, criticism, news reporting, and scholarly reports. However, there are no clear rules defining what number of words you can use of a selected work, or how many musical notes or stanzas will qualify as fair use, or what percentage of an audiovisual work can be used and still be considered fair use. Instead, whether a particular use qualifies as fair use depends on a number of circumstances that the court will look at, and it's very fact-specific. For this reason, I say that fair use should be only used after you have analyzed the following factors. And these are the factors that the courts will look at. They'll look at the purpose and the character of the use of the work, including whether the use is of a commercial nature or is for a nonprofit or educational purpose. Second, the courts will look at the nature of the copyrighted work. Is it a highly creative work, or is it less highly creative? News reporting is sometimes considered less highly creative than, say, a sculpture or some artistic work. Third, the courts will look at the amount of the work that is used in relation to the work as a whole. And fourth, the courts will look at the effect of the use of the copyrighted work on the potential market for the copyright holder. Is your use of this work denying the copyright holder of making a profit? Or is the use actually encouraging people to go off and buy the copyrighted material or add to the market value of the material moving forward? Now, while the courts will look at all four factors, there is no one factor that is the dispositive of whether or not something will qualify as fair use. And depending on the jurisdiction, different courts have come out different ways on whether or not a certain use is considered fair or not. So now let's talk about the public copyright license, which I mentioned earlier. This is also known as an open copyright license, or the main one that we see is the Creative Commons license. This is, again, when a copyright holder gives permission to let others use their work in ways that would otherwise infringe on their copyright by providing a license to obey certain terms and conditions of the license. Creative Commons licenses. There are a number of different Creative Commons licenses that are used. For example, most Creative Commons licenses will, at a minimum, require that you give attribution to the copyright holder. Many of them also state that you have to share your materials if you make any kind of modifications or derivatives of the work, the same way that this material has been shared with you. Some of the Creative Commons licenses will say that they cannot be used for commercial purposes, and some say that you can't change or modify or make derivatives of the work. You have to use the work as is. So it's very important that if you rely on using Creative Commons licenses, that you look at the terms and you abide by those terms to avoid infringing on the license. I'm going to spend a couple of minutes now talking about music licensing and music and copyright, because it is such a convoluted and complex area of copyright law. So there are a number of different types of music licenses, because when we talk about music, many times what people don't understand is that we're talking about three different copyrightable elements. First, we're talking about the musical piece, the composition. That is a copyrightable element. Second, we're talking about the lyrics or the words. Again, that is a separate copyrightable element, and there could be two different people that each own copyright to those things. Third, we're talking about the sound recording. So the artist who records that music, that sound recording has its own copyright protections that attach to it. And for this reason, we have a number of different licenses that you need to be aware of whenever you're thinking about using music. First, you have the master use or dubbing license, and this covers the actual recorded version of a song. These rights are usually held by a record label or sometimes the artist. Then you have performance rights, and these allow you to perform a work in public. And performance rights are usually licensed through a PRO, or Performance Rights Organization. The three big ones in the United States are BMI, ASCAP, and CSAC. And these rights are usually held by the composer of the music and of the lyrics. The next license we have to think about is a mechanical license, and this allows you to reproduce a song. So this is needed to reproduce and distribute a recording, such as making a DVD or a CD of music. And there are rights societies that usually manage these rights, the big one being Harry Fox Agency. The last license that we need to be aware of is your synchronization license. And this is the license that's required whenever you want to use a musical work and synchronize it with any kind of visual element, such as a video or pictures in the background. So this is a license that might come into play if you want to put music on a website or put music as a background to a PowerPoint presentation, for example. And for this kind of license, you actually have to reach out to various owners of various copyrights, because you're dealing not just with the musical composition and the lyrics, but you're also dealing with the actual recorded version of the song. So there are not many rights organizations that manage these rights. Instead, you have to reach out to the copyright holders in most cases. So what about music in church? Well, under the US copyright law, there actually is an exemption that is given for churches to use music, but it's a very specific one. What Title 17 of the United States Code, Section 110 says is that performance of a non-dramatic literary or musical work, or of a dramatic musical work of a religious nature, or display of a work in the course of service or place of worship or other religious assembly shall not constitute infringement of copyright. So what does this mean? It means that if you're singing music in church, that you're free to do that, even though it would otherwise constitute copyright infringement. This applies to congregational singing and special music or background music that is played during religious service for live in-person services. It does not cover, however, streaming or copying lyrics to display. It only covers the performance in person during religious service. So especially during this time of virtual service for many churches, this specific exemption within the US Code does not cover much for what we're actually trying to do. Well, in response to this, there are actually a number of licenses that are offered, and we'll talk about those in a bit. So let's talk about your CCLI and CCS license. Your CCLI license covers a number of things. The first one is called the copyright license, and this allows congregations to print or display the lyrics to music without violating copyright law. Absent this license, you would have to get permission from the copyright holder if you're planning on using a copyrighted song during congregational singing. CCLI also offers a streaming license, and very recently they've added a Streaming Plus license, which actually has a lot of benefit because it allows you not only to stream your services, the musical portions of your services, but it also allows you to use master tracks such as background music, and this has never been offered before through this service. The last thing that I recently found out about CCLI Streaming Plus license is that it allows you to have a virtual choir set up, which again was not allowed prior to COVID and the impact that's had on churches. So now if you're using a song that is found under the CCLI repertoire, you can have a group pre-record the music and stream that music during church service without violating copyright if you have that license. Now, another option that many churches rely on is your CCS license. And they have a performance license, which is used for any kind of musical work that's used outside of a religious service. So for example, if your church has a church social or if your church has a school, the CCS license is beneficial for that because it allows you to perform music during those events and in those venues. And it also has a worship cast license, which is a streaming license similar to the CCLI license. What I will say about both of these licenses is they're relatively inexpensive. They are scaled towards the size of your church. And I do recommend that you at least reach out to both of these companies, these organizations, which are geared again specifically towards religious organizations, to see if it covers the needs of your church. Now, many people ask, well, what about hymns? Aren't I free to use hymns? Don't we own those? And the answer is, it depends. Many hymns in our Seventh-day Adventist hymnal are within the public domain. In fact, the vast majority are. So if you want to use a song like Amazing Grace, then you're fine to do that because that song's in the public domain. You can display the lyrics, you can change the lyrics, you can rearrange the song without any penalty. But if you're looking to use a song such as We Have This Hope, which is one of our Adventist standards, that song is actually still copyright protected. And so you have to go through the same analysis that you would with any other kind of musical work. You need to see if it's covered under a CCS or a CCLI license if you want to display the lyrics, or you need to reach out to the copyright holder if you want to make modifications to the song or you want to put it onto a CD or DVD to share. So just because a song is included in the hymnal, it does not mean that it is free for us to use. So let's talk about copyright and social media. Because many of us are streaming our services through social media platforms such as YouTube or Facebook, it's important that you read the terms of use and you follow the community guidelines and standards that are set up by these platforms. You should also know that when you're posting materials, that you're giving these social media platforms some rights to your materials. Most social media platforms have terms that say that you're giving them a non-exclusive license to reuse your work. So that's something to be aware of. Also, when you post things, make sure that whatever you're posting, you have full permission to post or to repost. Just because something is on a social media platform, it does not mean that you've been given the right to use that material any way that you want. If you find videos on YouTube or images on Facebook that you want to reuse, you still need to find out who the copyright holder is and get the necessary permission. Otherwise, you are infringing on copyright and there can be penalties that are involved. So here are some common copyright mistakes that you should be aware of. Just because something is available on a social media platform or even just on the internet as a whole, if you find something on Google, it does not mean that it is in the public domain and free to use. It just means that the copyright holder has decided to share that material on the social media platform or on Google. This has gotten some of our ministries into trouble in the past because they have found images and they've used those images without doing the due diligence of looking to see who owns those images. And oftentimes there will be, again, managers of the images or rights organizations that will then come and find the entity that has misused the image and then request a license or a fee in order to avoid litigation. So the easy fix to this is make sure that you do your due diligence and look to see if the image is copyright protected. If you can't find the owner of the copyright, don't use the work, because not being able to find the owner of the copyright does not save you from facing copyright penalties down the road. Also, the second big mistake is that people sometimes assume, again, that that C symbol, if it's not next to a work, that it's not protected by copyright. Again, this is not a requirement in the US or in many countries. You do not need to have the copyright symbol for a work to have copyright protection. The third type of mistake that I commonly see made is that people will get permission for one type of use. But they don't get permission for all the uses that they want to use this particular copyrighted work for. Also, just because you see that one of our denominational entities such as the General Conference or a division or union has posted an image or used an image, it does not mean that you then have the right to also use that image. Oftentimes we're using images under a license or using music or articles under a license, and we only have limited rights, which means that we can't share those rights with any other entity, even if you are still a ministry within the Seventh-day Adventist Church. So that's just something to be aware of. Before I end this presentation, I want to talk briefly about trademarks, because this is one area that our church is really trying to do a good job of monitoring and protecting, especially our church's trademarks. So let's talk about what a trademark is. A trademark is a distinctive word, phrase, or logo or sign, or even a smell or sound that identifies a certain good or service or product that is provided to individuals or the community or consumers. And it's used to identify those products or services with a particular source of those services. So some examples of trademarks could be the Nike swoosh sign, for example, or the McDonald's arches, or even the smell of Play-Doh. That has now been given registered trademark protection. Also shapes. So the shape of the traditional Coca-Cola bottle is trademark protected because, again, when you see those images or you hear the certain sounds or you smell certain things, you automatically associate those with the source of those goods or services. Our church also has a number of trademarks. We have images and words that we want people to identify with the Seventh-day Adventist Church. And these include, but are not limited to, the name Seventh-day Adventist, the name Adventist, and our church logo. These registered trademarks are owned by the General Conference Corporation, and under our working policy, we have certain guidelines for who can use these marks and who needs to get specific written permission before they can use the marks. So while denominational entities are able to use our marks for certain purposes, any supporting ministries or independent ministries or individuals that want to use our trademarks first have to get permission in writing by the General Conference prior to use. This means that if you want to use the flame logo for a personal ministry or for an independent ministry, you first have to reach out to the General Conference Corporation as the owner of the trademark. One note on this point is that even though denominational entities such as churches and other official denominational ministries of the church are able to use our logos, one thing you're not able to do is to modify those logos. So what you can see here are examples of the flame logo being modified or misused. We have identity guidelines, which have been produced by our communications department, and we do monitor the use of our logo. So if you want to avoid getting a letter from me or someone else at OGC telling you to please stop using or misusing our logo, the best thing to do is to use the logo as it is within the terms of the guidelines presented by the communications department. And you can find these guidelines at identity.adventist.org. Well, I know that this was a short presentation and there will be time for questions at the end, but I hope that this at least gives you enough information to begin thinking about the use of copyrights and trademarks within your church and also as part of your ministry. If you have any questions, please feel free to reach out to the General Conference Office of General Counsel, and we'd be glad to answer any questions that you may have. Thank you.